Hi. So I'm very happy that we reached this episode, episode. Yung goal ko kasi crimrev playlist until alternative circumstances and then pause. Tapos may trabaho pa ako bukas. Yung gagawin ko is aayusin ko yung civrev notes ko this week, Monday na pala, no? Ayusin ko yung civrev notes ko this week. And then, sisimulan ko yung civrev playlist sa weekend. Hanggang family code. Tapos, family code muna. Tapos, ipopost ko yung civrev. Isa-start ko yung polyrev until legislative or judiciary kung kaya. Tapos, ipopost ko ulit yon and then babalikan ko yung crimrev hanggang sa matapos. Or i-alternate ko siya. Depende. Hanggang sa matapos yung civrev, polyrev, at saka crimrev ng December. Tapos, sa December, sa bakasyon, sisimulan ko na yung lab rev. Yun yung uunahin ko. And then, tax rev. Tapos, mga January, February, pag natapos ko na yung lab rev at tax rev, I'm gonna start with crimrev and remrev. Nakalimutan ba ako? Pero basta ganon. Ganon yung goal. So, ayun. For this video, I'll be discussing alternative circumstances. And then that will be the last episode for crimrev playlist for now. And then just give me a week to prepare for the civrev playlist. And then I'll start uploading civrev videos this weekend. Ganon. Ayan. So, that's it for now. Okay. Alternative circumstances. These circumstances could either aggravate or mitigate the liability of the accused. So, the following are alternative circumstances. Konti lang to. Intoxication due to consumption of alcohol, relationship of the offender and the offended party, degree of instruction or education of the offender. Ito lang yung tatlo. So, intoxication due to consumption of alcohol. Ano yung application niya as a mitigating circumstance? So, first, that at the time of the commission of the criminal act, the accused has taken such quantity of alcohol as to blur his reason and deprive him of a certain degree of control. And that such intoxication is not habitual nor subsequent to the plan to commit the felony. But this is a rebuttable presumption. So, to be mitigating, the accused's state of intoxication must be proved. Inaamin niyang lasing siya at that time, pero yung pagkalasing niya, yun yung reason why nag-diminish yung kanyang freedom to act. And nawala naman siyang intention to commit a wrong, pero because of the alcohol, he was able to do things that he didn't mean to do. Parang ganon. So, nabublur yung reason niya and nade-deprive yung degree of control niya. So, ano yung lacking dito sa agents of voluntariness? It's the freedom, the intelligence, and the intent. Ano siya? Parang diminished. So, mitigating lang siya kasi hindi mo siya masasabing complete absence of the agents of voluntariness. Pero dapat hindi habitual. Kasi pag habitual, pag lasenggo yung tao, then i-mitigate mo pa ba yan? Kasi lagi siyang ganyan, diba? Or, hindi rin mitigating if uminom siya para magkalakas loob na mag-commit ng crime. So, yun. Yun yung for it to be mitigating. For, aggravating ba siya if you use it to, para magkalakas loob ka? I'm not sure. Yeah, I guess. Yun yung kapag ka hindi siya pasok, I guess sinabi ko, Sorry if I'm guessing. If hindi siya pasok, then magiging aggravating siya. Parang ganon. So, next is, relationship of the offender and offended party. Again, this is a circumstance that is personal to the person having relations, to the offender having relations with the offended party. So, again, kapag conspiracy yan, as I said, yung magkiklaim lang ng circumstance of relationship, whether it is aggravating or mitigating, is only the person that has relationship to the offender. So, yung mangyayari is aggravating, for example, may conspiracy, group of people, 'di ba? Usually shared liability 'yan. So, kapag ka yung isa dun sa group is, for example, husband ng victim, then yung relationship ng victim at dun sa husband niya, yun lang yung mag-a-appreciate ng relationship. Hindi siya magki-carry over sa mga kasama niya. Parang ganon. So, relationship shall be taken into consideration when the offended party is the offender's spouse, ascendant, so parents mo, grandparents mo, pataas, descendant, anak, apo, pababa, diba? Legitimate, natural, or adopted brother or sister, and relatives by affinity in the same degree. So, ibig sabihin, mother-in-law, father-in-law, daughter-in-law, son-in-law, or sister-in-law, or brother-in-law. Application of relationship as mitigating circumstance sa robbery, usurpation, fraudulent insolvency, arson, and in crimes classified as less grave felonies or light felonies and the victim is a relative of lower degree. So, yung concurrence nito is required. Yung concurrence dun sa dapat yung crime classified as less grave felony or light felony, tapos yung victim is a relative of lower degree. So, yung dalawang requisites na yan kailangan. So, again, sa robbery, mitigating circumstance. Sa usurpation, mitigating circumstance. Sa fraudulent insolvency, mitigating circumstance. Sa arson, mitigating circumstance. And lastly, sa crimes classified as less grave felonies or light felonies and yung victim is a relative of lower degree. So, 5 yan. Application of relationship as exempting circumstance. In theft, estafa, malicious mischief, if the offender and offended party lives together, so malicious mischief, and in crimes classified as grave felonies. Application of relationship as aggravating circumstance, so aggravating naman. If serious physical injury is committed by the offender, not because of excessive chastisement against his child, whether legitimate or illegitimate, or any of his legitimate other descendants. Alam ko yung chastisement, ito yung pinapagalitan mo, dinidisiplina mo. Tingnan nga natin kung tama. Para sure tayo. Wait lang, Google natin. Yeah, severe criticism or punishment. Severe. Severe. So, punishment nga. Homicide or murder, acts of lasciviousness, rape by a father or stepfather against his daughter or stepdaughter, rape by the accused of the minor daughter of his common law spouse. Common law spouse meaning living as husband and wife pero hindi kasal. Rape by the accused of his sister-in-law. And lastly, degree of instruction or education of the offender. Low or lack of degree of instruction and education is mitigating. High degree of instruction and education is aggravating, may condition, when the offender took advantage of his learning in the commission of the crime. Degree of instruction or education must be proved positively and cannot be based on mere deduction or inference. And exceptions wherein degree of instruction or education is not applicable is for crimes against property, crimes against chastity, treason, homicide, or murder. So, discuss tayo ng kaso. People versus Atop. Okay, kwento ko lang. Kung gusto nyo, basahin nyo lang original, pero, yung parang pinaka-summary lang. So, si Regina, meron siyang lola. Yung lola niya, meron kinakasama. Pero hindi niya ito lolo. Hindi kasal yung lola niya dito sa kinakasama ng lola niya. Parang live-in lang ba, ganon. Tapos, they live in the same house. Tapos, si Regina, nung 1991, diba, 10 years old pa lang si Regina nito. Fininger siya ng ng kinakasama ng lola niya. Tapos, sinumbong niya pa sa Okay, so medyo i-detalye ko na ng konti kasi medyo nadi-disturb din ako sa kasong to So, yung lola niya, si Regina, sinabihan niya yung lola niya nung nangyari. Tapos sabi ng lola niya, ito talaga naiinis talaga ako dito. Sabi ng lola niya, okay lang yan, it's just a manifestation of fatherly concern. What the hell? Diba? Tapos, next incident, naging 12 years old na si Regina, 1992. Yung kinakasama ng lola niya, pinuntahan si Regina, tapos, tinanggal yung panty ni Regina, tapos in-insert yung male organ niya into her vagina. Tapos, ginag siya para hindi siya manlaban and tinutukan ng kutsilyo. So, yon. Tapos, nangyari siya ulit a year later, 1993. Tapos, 1994, nangyari na naman ulit. Sinumbong na naman niya sa lola niya. Yung lola niya, di naniwala sa kanya. Nakakainis ka, lola. Tapos, noong 1994, naulit na naman. So, ilang beses na? 1991, 1992, 1993, tapos 2 times sa 1994. Yung una is, inulit na naman, sinumbong niya sa lola, di naniwala sa kanya. Tapos yung pangalawa naman, mga ilang days lang after that same year, minolestya siya nung kinakasama ng lola niya sa presence ng aunt niya at ng dalawang dalawang niece ng molester, ng offender ni Atop, Tapos yung dalawang bata pa, sinipa pa siya para tumigil siya. Nakakainis, pinagtulungan siya ng mga bata, pero syempre wala namang magagawa kasi mga bata Tapos yung nangyari dito, parang umuwi siya dun sa grandfather niya, si Regina, umuwi sa grandfather niya sa father side. Pero, pinilit talaga nitong ni Atop na kunin si Regina. Kinaladkad pa talaga niya. Tapos, parang inabuse pa niya. Like, sinaktan niya para bumalik. Tapos, it was only the next year, January 1995, na nagreklamo na si Regina. Kasi, sabi ni Atop, papatayin niya si Regina. So, hindi pa kinwento ni Regina masyado yung details, pero eventually, kasi parang takot siya, pero eventually, sinalaysay niya yung everything. So, hindi na natin, iko-question kung liable ba si Atop or hindi. Of course, he's liable, and yung statements ni Regina was appreciated by the court. Yung issue dito with regard to alternative circumstances is yung relationship ba ma-appreciate as aggravating. And yung ruling ng court is hindi. Kasi hindi kasama doon yung relationship na sinasabi ko kanina. Wala doon yung kinakasama ng lola mo. Wala siya dun sa, it's an exclusive list. So, hindi naman siya mako-consider na ascendant or hindi naman siya mako-consider as affinity sa same degree kasi hindi naman kasal yung lola niya tsaka si Atop. Kinakasama lang naman to ng lola niya. So, because there is no blood relationship or legal bond that links Regina kay Atop, dahil common law husband lang siya ng lola niyang nakakainis, wala, hindi siya ma-appreciate as aggravating circumstance. But yes, merong liability dito. He was found guilty. So, ox na siguro yan. Okay. Ano pa yung case na pa natin i-discuss? So, yun. Okay na yun for okay na yun na case for alternative circumstance. Basta dito, may case akong titignan dito na yung lack of instruction. Kailangan sa lack of instruction, ginamit yung knowledge or education para mag-commit ng crime. Na-take advantage na yun. Kung hindi naman na-take advantage, then hindi siya ma-appreciate. Okay. So, last topic na didiscuss natin is absolutory causes. Absolutory causes, those were the act committed in a crime. Those were the act committed is a crime, sorry. Those were the act committed is a crime, but for reasons of public policy and sentiment, there is no penalty imposed, such as in first, instigation, second, pardon by the offended party, and third, other absolutory causes such as death under exceptional circumstances in Article 247. So ito yung minention ko sa previous videos na if the husband, for example, chances upon his wife having carnal knowledge with someone else, and because of the passion and obfuscation, pinatay niya either one of them or both of them, wala siyang liability, parang destero lang. Accessories in light felonies in Article 16 of the RPC, spontaneous desistance in Article 6 of the RPC, prescription of crimes in Article 89 of the RPC, accessories exempt under Article 20 of the RPC, exemptions from criminal liability for cases of theft, swindling, malicious mischief, by virtue of his relationship to the offended party in Article 332 of the RPC, trespass to dwelling to prevent serious harm to self in Article 280 of the RPC, and discovering secrets through seizure of correspondence of the ward by their guardian in Article 219 of the RPC, and lastly, acts not covered by law and in cases of excessive punishment. So again, if an act, no matter how morally disturbing, if there is no law punishing it, it's not a crime. So what is entrapment? Entrapment is employment of ways and means in order to trap or capture the lawbreaker in the execution of his criminal plan. So ito yung mga buy-bust operation, mga ganyan, entrapment. Instigation is the means by which the accused is lured into the commission of the offense charged in order to prosecute him. The law officers conceive the commission of the crime and suggest it to the accused, who adopts the idea and carries it into execution. Instigation is recognized as a valid defense that can be raised by an accused. So defense to ng accused, hindi ng nag-instigate. To use this as a defense, however, the accused must prove with sufficient evidence that the government induced him to commit the offense. So yung entrapment, pag na-entrap ka at successful yung entrapment, pag nahuli ka dyan sa entrapment, liable ka. Pero pag instigation, maaring hindi ka liable kasi parang ininduce ka inimpluwensyahan ka, parang minanipulate ka to commit the crime na hindi mo naman dapat i-commit. So, yun yung instigation. Instigation versus entrapment. There is entrapment when law officers employ ruses and schemes to ensure the apprehension of the criminal while in the actual commission of the crime. There is instigation when the accused was induced to commit the crime. The difference in the nature of the two lies in the origin of the criminal intent. In entrapment, the mens rea, the criminal mind, originates from the mind of the criminal. Pag entrapment, hinuli mo lang siya sa normal course of business na criminal talaga siya. The idea and the resolve to commit the crime comes from him. Pero sa instigation, it's the law officer who conceives the commission of the crime and suggests it to the accused, who adopts the idea and carries it into execution. So pag ma-discover na na-instigate siya or there was an instigation, of course hindi siya liable. The legal effect of entrapment and instigation are different. Entrapment does not exempt the criminal from liability. Instigation does. Okay? Pardon by offended party. Crimes of adultery and concubinage shall not be prosecuted except upon a complaint filed by the offended spouse. The offended party cannot institute criminal action without including both the guilty parties, if they are both alive, nor in any case, if he shall have consented or pardoned the offenders. So, ayun. Okay. I guess see you dun sa civrev videos that I will upload this weekend. Ayun, have a great week. Bye.